It's the one that says, given the evolving nature of this undertaking, your committee recommends the minister establish an independent task force.
Yeah, okay, so let me speak to that. The part that the chair was just speaking to, colleagues, the recommendation in the third paragraph talks about the committee recommending that the minister establish an independent task force to monitor and evaluate the implementation of this act and to provide public reports on the implementation and outcomes of this undertaking in accordance with the principles of the legislation. The reason for this is that there are so many issues that have been talked about, and people have come at trying to solve those issues in many different ways. Some have proposed amendments. There are other approaches where people have rejected certain ideas but have said we need to do more research. There is no doubt in my mind that the implementation of this complex public policy will hit road bumps. It's going to. There will be problems. And it's one of the reasons why, we've heard people talk about the need to be able to flexibly respond, whether it's regulation or in other ways. It's also the reason why I think this committee has focused on and brought forward amendments that cause various reviews to be tabled in a different way, and a 5-year review on amendment in addition to the tabling the 3-year one reports that are already referred to in the legislation. This proposal is not about doing something at the end of 3 years or at the end of 5 years. This is about having an expert committee, something akin to a task force, although depending on the issue, the experts may change because matters with respect to the administration of fines and penalties and under the criminal code or under provincial statute are quite different than public health issues. So there may be variable experts brought to the table. The bill actually contemplates in section, I think it's 151, but it does contemplate that the minister is authorized to contract experts to come in and provide advice. So the ability to do this is already contained within the legislation. This is just an observation saying we think you need someone to be monitoring on an ongoing basis on some of these key policy areas and to be giving you advice as we hit the road bumps about course correction. I think anyone who works in complex public policy knows that developmental evaluation is an appropriate and best practice to watch as things unfold, to see where there are problems and to course correct. And you need good advice on that. I don't think it can be done just within the department, although the secretariat that's been established to monitor this legislation can provide a supporting role to these various expert groupings that come in. So that's the reason behind it, Mr. Chair. Thank you.
Okay. Any further? Yes, Senator Seidman.
If I might just ask a question about it. I know that in various studies that Social Affairs has done, very often we've recommended a kind of oversight body because things get very complicated. So you have like a steering committee or something to manage all the component parts. And I get a sense that there's a bit of a flavor of that here for monitoring and evaluation. My only question about it is, so the problem always is with things like that, who's in charge and who's the boss and who do they report to and who has real control. So you have an independent task force, but are they really independent or do they report to the minister? I wonder. And where does Health Canada fit in? Because we've established that Health Canada does an awful lot of surveillance and monitoring, and we've asked, in fact, the minister to report back to us in 3 years, and so I'd like to know how this fits in with that.
So I think those are all good questions. It's one of the reasons why it is not entirely prescriptive in terms of what shape that takes, for the very reasons that you set out. Let me tell you where we heard this. We began in our office to do a lot of work on the mental health issue and concerns about the mental health issue. And beyond the testimony that's been at various committees, we reached out and spoke with a large number of people. Myself, I called the head of CHIO to talk about children's mental health and, CAMH and other organizations. And what I heard over and over again, because initially I was looking to recommend some kind of a FedProv process on mental health supports and services more urgently as a result of this legislation. And I heard over and over again, you know what, we don't need another strategy. We don't need another study of that sort. There's lots of recommendations. We just need to monitor. In that case, the dollars the feds had put forward for mental health and how they're being spent by the provinces. And in this case, that led a number of them to a recommendation that started to develop about 3 weeks ago, saying that we really should have some kind of a independent monitoring committee that can provide good advice. The reason that we didn't sort of say one oversight body or whatever is because of the complexity and the number of different areas of expertise that would need to be tapped into. So I think that's all, part of what would have to be considered. But, your question's a good one. It's not prescriptive for the reasons that I've suggested.
That's fine.
Okay, anything else on this? Can we adopt, do you want to adopt this? Is that agreed? Carried. Okay, and now we have a series of observations coming from Senator Seidman based on various things coming out of different committee witness or recommendations. So we'll start with number one. If you could just read the part that's in the bold and then whatever you want to say.
I'm going to go through the first four. Okay, the first one is your committee urges the federal government to limit the minimum age for legal cannabis age to 21 instead of 18 to protect the developing brain of the youth. And this is a recommendation is supported by the testimony from the Canadian Medical Association. Dr. Jeff Blackmare from the association testified to the committee on April the 18th. And he said, if you're asking if there is a consensus in the medical profession on the age, there is, and it is 21. We'd like to see that across the country, the CMA is the only body that represents all physicians, and you have heard from our esteemed psychiatry colleagues as well, so there's actually a medical consensus on that age. So that's the first one.
Okay. Anybody else on that? I would disagree, if I can comment on that there was any medical consensus. There were a lot of medical people, including the people from CAMH, that wouldn't have agreed on this. And I think what we said at the end of the day, and I think there's another observation to that effect, is that there needs to be a special campaign effort to make sure that people in this age group, up to even 25, are getting the right information that they need to be able to make a decision. But if you can make a decision at age 18 on all sorts of things, including voting, you can make a decision on what's good for your health, and if you're given the right information, but not to move the age from 18 up to 21. It's 18 in the federal law, but it can be adjusted by the province to make it in coordination with their drinking age, which is 19 in the case of Ontario and some other provinces. So I would hope we would not support this. Senator? Oh, yeah, well, sure. But there were a lot of other people. I mean, it's easy to be selective about where you take your evidence from because there's all sorts of evidence to the contrary. Okay, Senator Lankin and then Senator Gold, I think. Was Senator Lankin?
Yes.
Yes.
In fact, I think many committees heard conflicting evidence on this, but there's lots of evidence on both sides, how grounded any of it is. The most recent evidence that I'm aware of is the JAMA psychiatry report from the States, and it is a meta-analysis of all of the research that's been done on the issue of youth and cannabis and the impact. And they come to a very bold statement after reviewing all of the studies that have been done, that the impact is minimal, and there are specific instances where there is impact, where someone has thank you, that's what I was looking for, predisposition to schizophrenia. It may cause an earlier onset. The risk factors in terms of age of beginning, but they're talking about beginning as a teenager, daily consumption, heavy abusive consumption over a prolonged period of time. There is some indication that correlates with other activities. The causal relationship isn't proven. So there's a lot to be done here. I don't think that it is appropriate to recommend an age. I think there's been a lot of policy work that's been done to try and land on an age, that it's not just medical evidence based, but the medical evidence doesn't support one or the other, the government's position or the people that have come forward. saying that it should be 21 or 25, some people have suggested. So I don't think it's appropriate for us to be looking at recommending they consider changing that age, but I do think that it is appropriate to make some kind of an observation about the kind of research that needs to be directed against that, and to provide over time a more sound evidentiary base. And I think as that happens, that's why you want government to be able to take advice from people who are on the leading edge of this, and to be able to respond nimbly if possible. So again, the nature of the concern is one that I agree with. Actually, you know, the hard recommendation, you're saying in terms of changing the age, there is no medical evidence, there's no evidence base to support that.
Senator Gold?
Senator Lankin made the points I was going to make even better, as always, than I could. But I do want to underline the point, because this was the research to which Senator Lankin refers came out in April, peer-reviewed. It should give us all pause when, in the face of the litany about how harmful cannabis is on the developing brain. I'm not minimizing the possibility that in some cases it is, and certainly the stronger and the more and the earlier you smoke, there is some risk. But it appears as if the most recent peer-reviewed research suggests it's not as harmful as some people are making it out to be. So let's not be on the wrong side of the science when we want to when we speak about this bill. I oppose this as an observation. 18 is the right age under all the circumstances.
Anything else on this? Okay. All those in favor, you want to do a show of hands or what?
We're going to vote, so I guess we should probably do a recorded vote.
Okay, recorded vote. It's an observation. Can we have a show of hands? All in favor of this observation? Moved by Senator Seidman. 1, 2, 3, 4, 5. All those opposed? 1, 2, 3, 4, 5, 6, 7. You had your hand up, yes, right, Senator Munson. So that is defeated. The second one.
Okay, the second observation, I move that your committee urges the federal government to introduce a mandatory alcohol and drug testing framework in safety-sensitive federal workplace. The recommendation is supported by the testimony from the federally regulated Employees Transportation and Communication. Employers have no moral judgment on the legislation of the cannabis. Our concerns are exclusively rooted in safety. We therefore ask the following, that your committee amend C45 in such a way as to introduce a mandatory alcohol and drug testing framework in safety-sensitive federal workplace that focuses on the full complement of the testing approaches: pre-employment, reasonable cause, post-incident return to work, and random. And these are comments made by Derek Haynes, testimony to our committee on April 26 to 18.
Anybody else on this? Senator Munson?
I'd just like to have an explanation of what constitutes safety-sensitive federal workplaces. Wouldn't every workplace in the Government of Canada, if you're going to make a decision on the lives of all of us, be a very safe, sensitive place? Or are you just talking about physical spaces? And I think it'd be discriminatory in some ways.
Okay. Do you have extra comments on it?
I think that we heard in testimony here that there were certain workplaces that are more sensitive than others, because these workers can either injure themselves or injure fellow workers or injure clients. So, for example, pilots, they're flying an airplane, conductors in railways, on trains, workers in using heavy machinery with other people around. So that you can think of a whole series of workplaces that are much more sensitive as far as safety matters are concerned, because of the vast numbers of people that they would affect if anything went wrong because somebody was under the influence of cannabis.
Occupational safety.
and we've heard a lot of testimony here in this committee, specifically, as we quote from FETCO, which is Transportation and Communications.
Yes, Senator Lincoln.
So just a question. As you know, I sat in on the committee from time to time, but I didn't, wasn't here the day that this testimony took place. So I'm looking for your understanding of this issue. There are a lot of workplaces where there are already policies or negotiated frameworks and collective agreements or whatever in place for testing. And then there are a lot of places where employers have looked to bring that kind of in and impose it where there have been challenges and it's been overturned in the court. I actually don't understand the need for this. I would think that in terms of workplace well, Senator Platt, I'm hoping maybe you can speak and help me. This is a genuine question. In workplaces, for example, Darlington, where my brother worked for a number of years, he had to do mandatory testing. He's a crane operator, right? Heavy equipment, high, all of that, and lots of potential to hurt others. That's part of the system that's in place. I believe that it's already in place for train conductors. I don't know about pilots. I don't know how they test pilots, if it's just on observation of whatever, but I know that there's lots of sanctions if you are intoxicated, whether it is legal, illicit, or alcohol. So why would we leave this to the government to do as opposed to workplaces to determine?
We were urged in our testimony to do this because places of employment were worried that they would be served with human rights violations if they tried to do this. So, you know.
That's currently the situation, isn't it? If they try to.
But you see if, yeah.
That's one side of the coin, but we also had other people at the table at the same time. The president of the Canadian Labour Congress was there and pointed out that there are existing protocols because there are problems with intoxication of people for alcohol and other kinds of drugs. So that there is a series of protocols that he felt were sufficient to deal with this. And the other entity we had there was the Canadian Centre for Occupational Health and Safety. And they're an independent agency that tries to pull the parties together and tries to focus on this. And they said there are those kind of protocols, there is that kind of dialogue going on. So, yes, there was one particular entity that said, yes, we'd like to make it compulsory. But that wasn't what was the total evidence put before the committee. So, Senator Gold.
I'll pass. It was just, I just wondered, given how dangerous driving is, why people seem to be opposed to mandatory alcohol testing for driving, but that's really another bill, so it's really, the question's out of scope.
That's another, another argument
of course,
for another day.
So I will not make the comment.
Okay, do you want just a show of hands on this? Okay, those in favor of this this particular observation, please show your hands. 1, 2, 3, 4. Okay, those opposed? 1, 2, 3, 4, 5, 6, 7. Okay, that loses. So number 3.
All right, the third one is I move your committee urge the federal government to work with provinces and territories to facilitate the development of the workplace impairment policy. This recommendation is supported by the testimony from a Canadian Centre of Occupational Health and Safety. Chris Moore from the centre testified to our committee on April 26 to 18. Typically, when a major legislative change happens that is going to have a profound impact in the workplace, there will be some major education programs developed. So far, I have not heard of anything like that around cannabis or impairment. Yes, there are lots of initiatives around mental health, violence, youth awareness, and all of these sorts of things, but I've not heard of anything around the impairment, were some of the comments that were made by Chris Moore.
Any other comments on this one? You want to agree to this? Yes. Okay, agreed. Number 4.
Four, I move that your committee urges the federal government to ensure that law enforcement be provided with the appropriate tools and resources to address concerns about continued illicit production, diversions, and sales of cannabis to the youth. This recommendation is supported by testimony from municipalities and of the Canadian Association of Chief of Police. The Deputy Chief Constable Mike Sear, Canadian Association Police testimony on April 30th. The division is one of our priorities, and we don't want to see the product diverted. As we said, youth have typically had it diverted to them through these types of means of lower production, so to try to give us more tools to address that situation was the reason that they gave us a testimony.
Any other comment on this one? Agreed? Carried. Number 5.
Okay, and I'll go with this. Your committee urges the Minister of Health to require mandatory health warnings for cannabis products, to include warnings about the danger of smoking cannabis, the danger of exposure to secondhand cannabis smoke, and the risks of combining cannabis and tobacco. And this observation is supported by many. But I will just tell you about the testimony for the Non-Smokers' Rights Association, who testified in front of SOCI and said, "We know from tobacco research that package warnings can be a highly targeted, effective, and cost-effective form of public education. However, the current proposal for 6 warnings includes no warning regarding the relative risks of smoked versus other forms of consumption, no warning of the dangers of exposure to secondhand cannabis smoke, and no warning of the risks of combining tobacco and cannabis. We urge senators to recommend that warnings on these issues be included in the list of mandatory health warnings on cannabis products." And that's what this observation does exactly.
Could I ask the officials, Mr. Austin, to perhaps tell us how this relates to what your plans are in terms of the regulations, if you have any concerns about all of this?
No concerns, Chair. It's the observation is consistent. I would maybe just read one of the warning messages that I think is topical. So the predominant warning would be cannabis smoke is harmful, with a sub-warning beneath that, harmful chemicals found in tobacco smoke are also found in cannabis smoke. And so this would be one of the 6 mandatory warning messages that the Senator made reference to. If there's an interest to have other types of warning messages, we've anticipated that over time the messages would need to evolve and change. And part of the research that you're referring to notes that you need to rotate messages so consumers don't become accustomed to them. So a diversity of messages is a reasonable thing that we've been thinking about.
Okay. We agree to this? Agreed. Okay, number 6.
Your committee heard evidence. Oh, sorry, I'll just read you the. Your committee urges that testing procedures for THC content be standardized to ensure accurate measurement to better protect consumer health and safety. We had testimony from the Chief Medical Officer in the Alaska Department of Health and Social Services, Dr. Jay Butler. And he said when we asked, and every state that we heard who's already done this, we asked them benefit of their experience. And he said, if there's a recommendation I would make, I think you want to think long and hard about how to standardize the testing process so that you get accurate measures. If you're going to do this in a way that is as safe as possible for the consumer and so that the consumer can be informed, the testing procedures have to be standardized. And that's what this observation does. It urges, the observation doesn't standardize, but it urges that testing procedures for THC content be standardized.
Okay. Mr. Costin, on this one, is that... Is that your intent in any event?
Yeah, I mean, other than to reflect that the Canadian Standards Council and other international standard-setting bodies are also seized with this issue, the need to identify and determine appropriate standards for THC testing.
Okay. Okay, can we agree on this? Agreed. Nope.
The committee urges the federal government to ensure that forthcoming regulations for edible products and other forms of cannabis should ensure that product packaging is child-resistant and does not appeal to young people, and that the type of available product should be strictly limited. So,
Oh, you might get general agree. Is this generally agreed?
yeah, no,
Agreed.
I don't have to
Carried.
go further, thank you.
8,
Okay, with number 8. I move in the committee, your committee urged the federal government to provide adequate and ongoing funding for sustained evidence-based cannabis education and prevention programs to provide Canadians, especially young Canadians, with knowledge about the health risks of the cannabis use.
Agree.
Agreed?
yeah, agreed.
Thank
Agreed.
you.
Number 9,
Your committee urges the federal government to impose a moratorium on reviewing the regulations of branding, marketing, and promotion of cannabis for 10 years. Now, this observation was recommended by Drugs Free Kids Canada, the same organization that the government partnered with to create Cannabis Talk Kit for Parents, one of the few educational initiatives that the government has undertaken prior to legalization. Basically, testimony to SOCI from Drugs Free Canada was a quote from them, a small excerpt, says this: "We've been closely observing the recreational cannabis industry and have huge concerns that they plan on lobbying the government to relax their tight regulations after a couple of years, their argument being that they need to differentiate their product from the illegal stuff. The youth segment represents the biggest group of consumers of cannabis, just like alcohol. If we relax the regulations to allow the marketing promotion of cannabis products, who do we think they'll target first? We propose that this committee include in the legislation a moratorium on reviewing the regulations on the branding, marketing, and promotion of cannabis for 10 years. The basis for this timeline is that it will take at least a generation to measure the true societal impact on youth to the legalization of cannabis. The government's approach to legalization of recreational cannabis was to better regulate and control the sale and distribution in order to protect our children. Let's not leave a crack in the door for our kids to become targets of exploitation by big business."
Senator Gold.
Well, it's really more of a question than a comment. I was just surprised by this because given all that we've heard about the importance of flexibility and adapting to all the moves that that the industry players would make, I would have thought that this actually might hurt our ability to protect kids from the kind of advertising and other targeting campaigns that Senator properly worries about. So am I missing something, Senator Siegman?
Because I'm missing something here. So there's an incorrect word here. It should read, your committee urges the federal government to impose a moratorium on loosening the regulations. Okay, I'm sorry. The language was taken directly out of the quote from Drug Free Canada, but of course, in context, you know, that isn't really what they meant. They meant loosening. So please try, I'm sorry about that. You're quite right.
Do you have anything further, Senator Gold or Senator Wu? Okay.
Senator Gold kind of stole the words from my mouth, but maybe there is a secondary question on whether loosening might actually be tightening the freedom of flexibility to make regulations more obstructive for young people. Loosening is a loosey-goosey word, if you know what I mean. So that would be my only remaining caution.
Yeah, if I could comment too, I think it's too imprecise, and I think it's unreasonable to suggest that something needed to be held in place for 10 years when there could be a shorter period of time where something is so obviously requiring some correction. I don't think, I think we've got to be fair to everybody in this thing, that if we're going to review, let's review them on a more consistent basis on all aspects of it, not just this particular loosening kind of aspect. So I won't be supporting this one. Senator Lankin?
I will be supporting this one. I think that the experience with the different industry, but related tobacco industry, and there are cross players, particularly on the marketing experience inside. The experience with that is it has been a constant battle for public policy to make gains. And I think, again, this is a recommendation, but I think it is like a shot across the bow to say, you know, we shouldn't be looking at loosening regulations right away. We're going to hear a lot about that. But there may be occasions where we want to tighten them, so I appreciate that, that addition. I agree with you that, you know, that's a valid point too, but this is a recommendation, and I think it's something that needs to be said at some point in time to give a focus to that concern that people have. So I will support this.
Okay, anything else? Okay. Pardon?
The new term, the new right.
Your committee urges the federal government to impose a moratorium on loosening the regulations on branding, marketing, and promotion of cannabis for 10 years. And you read the two lines before that. Your committee heard evidence that no further loosening of the proposed regulations on branding, marketing, and promotion of cannabis should be permitted until the societal impact on youth can be measured.
Okay. Yes, Senator Wu?
A moratorium is something that you put in place to stop a trend that is already agreed on. A moratorium and loosening means that you will loosen over time, and that you will just not loosen for the first 10 years. If you don't want to loosen, you say prohibit, not loosen. Moratorium is, I don't think it's the right word or the right connotation, because what you would have then is at the end of the 10-year period, if the moratorium on loosening is over, then loosening is the preferred path.
Let's not spend a lot of time on rewording this. If we're doing one word, then that's fine.
Yeah, it's not an amendment, it's just an observation, you know, and I think it's clear what it means.
I think if you said prohibit loosening the regulations, it would work better. I agree with Senator Wu. Prohibit loosening the regulations would
Okay.
work. That's one word.
Yeah, sure.
No, that's two words. Prohibit loosening is two words.
It's taking three
That's
words
okay.
and putting one in.
Yeah, okay, okay.
And then we do have to get the transfer.
Remember, these have all got to be translated too, and remember, this is being introduced into the chamber tomorrow, so there's not going to be a lot of time for them to get all this ready.
Well, I think you have them all in English and French, and if there's one word here and there to translate, I don't think it'll be a problem.
But just so I'm clear though, what is the change? I have that the word reviewing is changed for loosening.
Your committee urges the federal government to prohibit loosening the regulations on the branding. No? It sounds kind of funny, doesn't it? Leave the wording the way it is. Okay, let's leave it the way it is. Your committee urges the federal government to impose a moratorium on loosening the regulations on the branding, marketing, and promotion. That was the recommendation that was made to us by a pretty significant organization. Let's keep it.
Is that agreed? Okay. Next, number 10. It's carried. Yes, on division,
So, your committee heard evidence about the health harms of cannabis use. Furthermore, witnesses stated that legalization combined with the commercialization of the cannabis industry may result in the normalization of cannabis use. Your committee recommends that the Minister of Health act immediately to set aggressive targets comparable to the successful federal tobacco control strategy to reduce the number of youth and adult cannabis users. Would you like me to go?
Senator Gold?
Yeah, I'm now shy to say respectfully, but No, I don't support this. I mean, I don't support this. I don't think we have any reason to assume that, and I'm going to focus on adults because this includes youth and adults, and we get focused on youth, and understandably, we all have kids and grandkids. I don't see why we should assume that it's the appropriate policy and that we should decide today that responsible use by adults is something that should decrease as opposed to increase. I mean, if it increases and people are getting off opioids and stop, boozing themselves to death, I don't think that's a terrible thing. The point is, I don't have any basis for saying that this is the right way to go as opposed to saying nothing. So I'm not comfortable with this observation.
Anybody else on this?
I might just respond and say, but Parliamentary Secretary Blair sat right here at this very table twice and said exactly that was their intent, was to set a target. The health minister made an announcement that in 2021 she was going to set a target. So why wouldn't we recommend that they set those targets?
Smoking,
No, it was
cannabis? Cannabis in
it was on cannabis use.
Adult cannabis use?
Yep, and youth.
Youth,
15 to 24.
Well, I guess, price of being independent, I can disagree with Blair, I guess.
Okay, is it your wish to adopt this? Agreed. Okay, on division. On division, yeah, all right. That's okay. So the next one, number 11.
your committee heard evidence that other jurisdictions have implemented a seed-to-sale tracking system to help maintain the integrity of the legal cannabis supply. The proposed Cannabis Act would authorize the Minister of Health to establish and maintain a national cannabis tracking system to track cannabis throughout the supply chain. Your committee urges the federal government to ensure that the cannabis tracking system be operational upon the coming into force of the Cannabis Act.
Officials, whether there's any difficulty they see in that?
No, Mr. Chair, this is in fact our intention.
Okay. Well, there you go. Just pick up what their intention is and put it in a motion. You'll succeed.
That's the thing, is they
Okay.
haven't provided any indication about what the system will be rolled
Right.
out, so we hear it now. That's good.
Okay, anything else on this? Okay, is this agreed? Okay. So number 12. Yep.
Yes, if I may, this for observation would, this committee would read, this committee urges the federal government to not allow such operations, and that refers to outdoor cannabis cultivation, until they conduct a thorough public analysis of these and other concerns and produces through the normal process of the Canada Gazette a regulatory framework. And the first part of that, I'm sorry, I omitted to say, your committee heard evidence that outdoor cultivation is problematic in a number of ways. It will increase the potential for the diversion of cannabis to the illicit market, which is counter to one of the objectives of the bill. In addition, outdoor cannabis cultivation will not be as secure as indoor facilities, which operate under the strict regulation of Health Canada. And we heard about this from Canopy Growth Corporation, one of the largest, who expressed concern that permitting commercial outdoor cultivation by regulation will increase the possibility of domination by the illicit market and will discourage continued investment by licensed producers. Outdoor cannabis cultivation will not be as secure as our current indoor and greenhouse production facilities, and this recommendation was also supported by the testimony of the Honourable Benoit Bourque, New Brunswick Minister of Health.
Question, Senator Langton.
Yes, thank you, Senator Patterson. When you were speaking, you talked about outdoor commercial cultivation. Is that what you're talking about in this recommendation? And if it is, can that word be inserted? Only because of confusion over time with for plants home cultivation.
Good point. Yeah. Good point, yes. That should be the adjective.
Where, sorry?
Outdoor commercial cultivation, it's in the first sentence, it's not really in the recommendation. It refers to them as
Well,
such
it needs to go in,
operations.
it should go into the recommendation somewhere.
Well, such operations
Not
in the
allow
recommendation.
Commercial operations.
right? The number 12, the entire paragraph is the observation?
Well, but the part in bold is actually what you're recommending to the government. You should have it in there.
Yeah, okay.
Where are you putting that?
Where it says such operations, the committee urges the federal government to not allow outdoor commercial cultivation until they...
Outdoor commercial cultivation. Can I ask Mr. Costin again about the implications of this? I realize the big players in this wanted this kind of a provision to ban outdoor cultivation, but I thought some of the smaller players, this would have been an issue. Can you, maybe I've got that wrong, but just tell me.
No, I mean, this is a pretty significant policy question. The proposal that the government has put out through the regulatory papers that we've discussed earlier do propose indoor and outdoor cultivation. It does propose a number of security requirements associated with both indoor and outdoor at small scale and large scale. I believe what you're suggesting, Mr. Chair, is there were a diversity of views on the questions of indoor and outdoor. Some, as you referenced, one of the big companies certainly have expressed their concerns with the proposal. Others have noted that it can be done responsibly. It was an issue that was put to the task force. It was something they consulted on specifically. And when they made their recommendations to the government, they recommended that we allow for outdoor and indoor with appropriate safeguards put in place.
Thank you. Senator Gold?
It's just really a question, because I didn't attend any hearings on this, but were there any representations from any Indigenous communities or any intentions expressed about the desire to become part of the production cycle, but growing it outdoors? I wouldn't assume one way or the other, but was there any evidence one way or the other from Indigenous communities?
Not at our committee. Now, Mr. Costin.
So thank you for the question. When we did our consultations on our regulatory proposals, we heard directly a number of these diverse views. While I certainly don't deny that there were those who expressed concern, the strong majority of people that we consulted with expressed support. Many of them, and that would include representatives from Indigenous communities, noted that there was a certain, it was more economical to grow outdoors and certainly more environmentally sustainable. And so there were a number of arguments along those lines that were made. You can expect with the climate that we have in Canada that there were certain regional interests as well, where outdoor growing really isn't viable across the country. There are certain pockets of the country where the interests are greatest.
This should be handled very carefully because of the security issues. It doesn't say it can't be done. It just says it should be a thorough regulatory framework, a thorough public analysis of concerns.
Okay. What's the wish, committee members? All those in favor? 1, 2, 3, 4, 5. Those opposed? 1, 2, 3, 4, 5, 6, 7. That's defeated. Number 13.
I have a suggestion for the remainder of these, which all come from committees that were referred, were referred. And out of respect for the committees who spent a lot of time, and I'm assuming the observations come to us approved by the committees, I don't see why we would assume a proprietary error and override any of these. I don't, they're not going to change the legislation. They're just advice from committees who did take a lot of time to put their observations forward. So I'd put that forward as a motion on the floor.
These are not necessarily, they may be based on testimony in front of the committee, but they're not necessarily what was recommended by these individual committees. The matter is completely in our jurisdiction, and Secondly, the committee reports are reported into the Senate chamber as well, so they're there and on the public table as to what their recommendations are. If we're talking about just duplicating what they've already had, then we should stop processing any of these at all.
I thought they were from the actual committee reports.
Well, they're based on it, but they're not the wording that the committee used.
So why would we change the wording? I mean, you can just...
Well, they're not necessarily related to the recommendations that the committee made. They're part of the content and the reports from the committees, but they're not necessarily, certainly not verbatim what the committee had recommended.
Excuse me, with all due respect, the fact is that what you see in bold is the exact recommendation. That can't be an amendment. So what you have here are the observations that came from those 4 standing committees that did pre-study. That would be Foreign Affairs, Aboriginal, National Security and Defense, and Legal and Constitutional Affairs. And they submitted reports. There were unanimous recommendations that could not be amendments. They were just observations. And so, as Senator Stuart Olson so rightly puts forward, and it has been the principle that we've taken to this whole clause by clause, these 4 committees did substantial work, and there were unanimous recommendations for amendments and for observations. And we felt that it was critically important to put those forward for a vote at our committee meeting tonight when we did clause by clause, because they spent weeks of listening to witnesses and writing a report, and they had obviously insights that we didn't necessarily have, and out of respect for the work that these committees did, we felt that it was critical that we have the respect to put those observations and recommendations forward.
Report, I mean, the way it's been sounding to me is it keeps saying your committee, and if there's going to be an addendum to the clause by clause, it should be saying the Senate Standing Committee on Aboriginal Peoples recommends that as an observation. It's not us. I mean, but I've been pronouncing on things thinking it's your committee is this committee.
Yeah, but that's just duplicating what is already in the Senate, because they've already reported to the Senate. So what we should do is just remove the rest of these. We shouldn't deal with them at all. Now, unless you're asking us well, we also heard different evidence in some cases. And so we may come to different conclusions. We did that in the first few that we, there was at least 2 or 3 in the first bunch there that we said we didn't agree on, because it only pertained to some of the evidence. Whereas this, we did hear our own evidence. Now, if we're going to just say out of respect for the committees, then let's just leave it. Let's just not deal with any of this, because they've already got their reports in the chamber. So I would say we just, if you're saying this is all a duplicate, then let's stop it.
Well, but what it does say in the recommendation or the observation says, your committee, meaning Social Affairs, Science and Technology. So it means that we, our committee, who's turning in this report to Senate, supports the recommendation. That's what it says, your committee.
Us to do it automatically, and I don't think we are obligated to do anything automatically.
And I'm not asking us to do it automatically, but I thought out of respect for those 4 committees, that we should go through them and vote on them or agree yes or no, not vote on them, but just.
Well, all right, then she would Senator Stuart Olson withdraws her motion. So we'll continue.
Question on this?
Pardon?
I have a process question on this.
Sure. Okay.
I'm sorry, it's slightly different than what was just suggested, but I hear people, saying that the committees did a lot of work. Some of them heard different evidence than us. We may not agree with the conclusion, we may want to amend it or whatever, do we do that? Or instead, do we just append to our report an appendices of the observations that other pre-studies produced and not comment on them? That's another way to go, but they're there as part of the record that is sent over.
Well, they're already on the, they're already in the Senate, those reports. Yes, they're all, those Senates, yeah, all the committees reported to the Senate as well as to us. And we had different evidence and different people to come in as witnesses. So if we're being asked to deliberate on these various possibilities that Senator Seidman has moved as motions, then I think we've got to exercise our judgment on them. What the other committees have done, they've put it into the Senate. It's in the Senate, and it will be part of the overall consideration.
I just have one question about that. And I wondered if we were clear that all four committees tabled their reports in the Senate, because I certainly knew of two, but I wasn't. Did they? All four tabled?
All four did, and I believe the Aboriginal Affairs Committee report was adopted by the Senate.
Yes, that I do recall.
But all four were tabled. They're all part of the public record now.
Okay, fine, thank you. But they were supposed to report to us as well, so we had the obligation to consider their report since they did pre-study and they reported to us.
Okay, Senator Platt.
Well, Chair, Senator Stewart-Olson withdrew her motion. We are 3/4 of the way done through these observations. Now, all of a sudden, you're suggesting that we change gears. The amount of time that we've spent here in the last 15 minutes debating, we could have finished these last observations. So I strongly encourage us to continue with the rest of the observations and either approve them or reject them so that we can all go home.
Let's do that then.
Senator Stewart-Olson had changed that.
Yeah.
Agreed, Chair then wanted to do nothing.
No. I said you go one course or the other. You either.
Chair?
Yes.
Golden Knights 1, Washington 0.
Okay, so we are we're at number 13.
Mr. Chair,
Yep.
may I introduce 13?
Sure.
It reads, your committee notes the evidence presented to the Standing Senate Committee on Aboriginal Peoples about the desire of Indigenous communities to fully participate in the economic opportunities that the legalization of cannabis provides. Your committee supports the recommendation of the Standing Committee on Aboriginal Peoples that the Minister of Health reserve 20% of all cannabis licenses for production activities on lands under the jurisdiction or ownership of Indigenous governments to encourage a diverse, competitive cannabis market and to ensure that Indigenous peoples are in a competitive position to generate own source revenues and employment opportunities in this new industry. Mr. Chair, we did hear from Mr. Blair that issue is on the government's radar, that Indigenous Affairs Canada is supporting. I don't have to talk about it?
No, we all.
No.
Okay.
Yeah, no, I'm sorry. I'd like to hear from the official. I have a problem with the first part from what we've heard from the officials about the reserving of the 20%. The second part, absolutely no problem at all, to encourage a diverse, competitive cannabis market, et cetera. That I think is fine. But the 20% of all cannabis license, we did hear from, and I wonder if we can hear from Mr. Costin again about the difficulty of this.
Sure, thanks, Mr. Chair. I think the point you're making reference to is the way the current licensing program operates, and frankly the way it's proposed to operate in the future, is that there's no maximum number of licenses or minimum number of licenses anticipated. There's no quota system whatsoever, and so truly there are an unspecified number of licenses that can be issued, an infinite number of licenses, as it were, because the government's policy has been not to control or manage the market in any way that would allow for determining and allocating quotas of the market to different individuals or entities.
Okay. I would suggest we split that first part off and vote on the second part.
I'm sorry, Senator Patterson from the Aboriginal Committee, why did they put in the 20%?
Frankly, it was just an arbitrary figure that we picked to make sure that they were on the radar and that they were going to have an opportunity to participate in this new economic opportunity, given the paucity of own source revenues in First Nations on reserves. So we've picked that arbitrarily.
Well, the second part puts them on the radar, quite clearly. Encourage a diverse, competitive cannabis market and ensure that Indigenous peoples are in competitive position to generate their own source revenues and employment opportunities in the new industry, without getting into a number.
I would support you, Chair. If this 20% is just an arbitrary number, I don't think we should be making that a recommendation. There's got to be reason for a percentage in there.
Wow. Okay. So can we remove the first part, the Minister of Health encourage? Okay. The Minister of Health, take out reserve 20% of all cannabis license. So it would read, the Minister of Health encourage a diverse, competitive cannabis market, etc.
Come out and ensure that Indigenous
Yeah,
peoples are
right,
in a
I did.
competitive position.
Right.
Yeah, perfect.
Fine with
Is that agreed?
Yes.
Carried. Okay.
Mr. Chair, on 14.
Yep.
Can I try, I was heartened by the support for the bullets in my failed amendment. Everyone said, you'll recall I made an amendment about requiring the government to report back on critical issues identified by the Aboriginal Peoples Committee, development of educational materials, culturally and linguistically adapted, funding of mental health and addiction programs. So what I was going to suggest,
Excuse me for 1 minute, that's JS 15.
JS 15, thank you.
Okay.
What I was
Where are you
going to,
talking about putting it in, though?
I was
14
talking about
doesn't
putting
fit.
it in observation number 14,
That's an international one.
which is about the duty to consult under the UN Declaration on the Rights of Indigenous Peoples. And I was going to suggest that we alter this recommendation with material that's already been translated in JS 15, and it simply would say, your committee notes the evidence presented to the Standing Committee on Aboriginal Peoples in the context of Bill C-45 and Canada's international obligations with respect to Canada's duties as outlined in the UN Declaration on the Rights of Indigenous Peoples, specifically Article 19 regarding the duty to consult. And then I would add, in particular, your committee notes the recommendation of the Standing Committee on Aboriginal Peoples to ensure that consultation efforts include. And then we go to A and
1, little 2, little 3, little 4?
yeah,
and
that
all
list that I got, that many people said were, many members of this committee said were, they had no difficulties with. They're already translated.
Yeah, well, I see that, yeah. Okay, anything further on that? You want to do that? On 14, add that in? Is that agreed? Okay, that's agreed.